Advisory Committee. We're putting on this event in collaboration with SUAA, the State University Annuitants Association, and more specifically UIC United, which is the UIC chapter of SUAA. Merrill Gassman is the president and webmaster of UIC United. He's going to do some opening remarks, introduce our speakers, and tell you a little bit about the constitutional amendment.
Okay. Good afternoon, everybody. Has everybody received this amendment in the mail? Had a chance to look at it yet? If not, you should certainly do so before the election. This will, of course, be the subject of our presentations this afternoon. And by way of opening it, I would like to give you a very short summary without any legal language inserted other than what is necessary to understand the concepts. The amendment consists of 4 parts, A, B, C, and D. The first part, A, provides that all bills in the General Assembly that provide a pension benefit increase will require now a 3/5 vote of both houses of the General Assembly in order to pass, which is a revelation because bills normally require, except certain times of the year, a majority vote to pass. The first section goes on to define what a benefit increase is, and this is critical to our understanding of this amendment. It states that new pension benefits or enhancements to a benefit, including increases in the amount of the pension, reduction or elimination of eligibility requirements, or expansion of classes of whom may become a member of a pension system. All of those would be considered benefit increases. Increases in salary, however, would not be considered benefit increases. The second part of the amendment states emolument increases. You know what emoluments are? You probably heard of those. Emolument increases that increase a pension will also require a 3/5 vote by the appropriate governing body. This amendment will apply to, as we'll hear shortly, any governing body for any particular type unit of government. Now, what is the definition of an emolument increase? According to this document, a new advantage, profit, or gain by virtue of employment. For example, time off, a bonus, or other forms of compensation. Again, an increase in salary would not be an emolument increase. Third part, beneficial determinations will also require a 3/5 vote to pass by the appropriate governing body. Definition of a beneficial determination: an interpretation or application of pension law that reverses or supersedes a previous interpretation or application and results in an increase in the amount of pension or in the eligibility to receive a pension. And finally, what our speakers today would say is the most important and crucial part of the amendment, the so-called Section D. It's very short, to the point, but there's much debate over its meaning and implication, and that is, governing bodies may pass laws to further restrict benefit increases, emolument increases, and beneficial determinations. Further restrict, what does that mean? Well, there are at least 2 interpretations of the meaning and purpose of this whole document. The first one, which I consider to be the simple one, the proponents of which include the League of Women Voters of Illinois and U of I Professor J. Fred Geertz of Economics at Urbana, who's also director of the Institute of Government and Public Affairs and member of the CSRS Board of Trustees. This interpretation says that sections A to C, the first 3 parts of the amendment, are meant only to restrict the ability of a governing body in Illinois to increase the pension benefits of public employees by requiring a 3/5 rather than a majority vote. And the fourth section, Section D, simply gives these governing bodies authority to make it even more difficult to increase pension benefits, if they so choose. In other words, for example, require, say, a 2/3 vote to pass a pension increase. Now, the other interpretation, which I refer to as the sinister one, the proponents of which include our two speakers today, can be considered to be a Trojan horse of sorts, designed to undermine the pension non-impairment clause of Section 5 of Article 13 of the Illinois Constitution. I'm not going to go into further details. I'll leave that to our speakers. In addition to Professor Geertz, the League of Women Voters, and today's speakers, the amendment is opposed by SUAA, AFSCME, SEIU, IFT, IEA, UPI, and RTAC, and a number of other organizations. I will now introduce the first speaker, Professor Kindt from Urbana, whose brief bio you see in front of you. You can read it while he begins his remarks. But before we get going, I just want to thank UIC United member Jim Limber, who is doing the webcasting live of this event right now, and the event will also be archived for later viewing. If you would like the URL, it is www.ustream, that's with the letter U, ustream.tv/UIC /channel/UIC-United. Okay, Professor Kindt.
Well, thank you, Merrill. It's always nice to be here in Chicago. I was born in Chicago. I've been a professor at the University of Illinois, Urbana, for 34 years and counting. I see we've got the Professor Emeritus up there. My students would probably say Professor Demeritus. But I think Merrill did a great job of taking my whole lecture. So that was a good job, actually. And I did put down here the empty stool in case Michael Madigan wishes to show up. But just to keep you interested, I'm going to put on this stool $10 billion, which the state of Illinois has not collected from certain parties. And actually, it's $10 billion to $47 billion. So when Springfield says it's time to take, we really need money, ask them about this $10 billion. And I'm going to keep you guessing where it's coming from. It's actually $10 to $47 billion. Now, the other thing, if you saw my picture up here on the web.
The red tie.
Yes. Merrill was going to point out to you my picture with the red tie. And any other pictures you see, I usually have a red tie on. So I brought it today, Merrill, just in case you forgot to mention it. And here's the red tie. Red, white, and blue, patriotic. And I'm going to go through the first 10 amendments to the U.S. Constitution. The Bill of Rights. Amendment number 1, the Great Amendment, free speech. 45 words. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. 45 words. Amendment number 2, 27 words. Amendment number 3, 32 words. Amendment number 8, 16 words. Amendment number 9, 21 words. Amendment number 10, 28 words. Illinois constitutional amendment, over 700 words, more words, almost double the number of words that are in the first 10 amendments to the U.S. Constitution. Now, when I talk about our Bill of Rights, I wear red, white, and blue. When I talk about this 700 plus words, start connecting the dots. Can you connect the dots on this tie? Can you connect the circles, the triangles? Can you see where this is going? There is, I don't mean to be presumptuous, but I have 3 earned law degrees. Not that there's anything against getting honorary degrees, but I worked for these. And one of them is a doctorate of juridical science, and which is the interpretation of words. Why does this amendment have 700 plus words in it? And why is it a constitutional amendment as distinguished from simple legislation? If, as Merrill indicates here in his introductory remarks, the legislature wants to remedy certain things, they can simply pass laws to do that. They can, and if there are abuses, you can spot check those abuses and get rid of those abuses. You don't need a constitutional amendment to do this. And you don't need a 700 plus word constitutional amendment to do this. So that raises red flags. Obviously, there's a lot of legal talent out of Chicago, going down to Springfield, working on this language. Why do we need 700 words on this? You could say the same thing basically in 3 sentences for a constitutional amendment. Obviously, our forefathers did pretty well with the first 10 amendments to the U.S. Constitution. Well, I think the bottom line on this, according to my political science friends, is if you trust Springfield, vote for it. If you don't trust Springfield, vote against it. That's what my political science associates say down at the University of Illinois, Urbana, 150 miles south of you all. And the best thing about this is, from Springfield's perspective, is people won't even know what they're voting on. It's not on the ballot. The only thing on the ballot is an introductory warning plus a 3-sentence summary, which really isn't a 3-sentence summary, it's actually a 1-sentence summary. So people are going to be going into the voting booth and it's not going to be there in front of them. It's simply a trust us, here's a little summary for you, vote yes, vote no. This is a huge potential change to the Illinois Constitution. And allegedly, it could overrule or destroy or eliminate the constitutional protections from the 1970 Constitution, which prohibit the non-impairment clause, which prohibits the reduction or elimination of earned benefits. Which leads to another point, another red flag. Why was this last paragraph, which is the controversial paragraph, basically added as an afterthought at the end of the process? Why did this mysterious paragraph show up at this point, at the end of the process, right before the vote or before the voting got going? And why is it at the very end? Why wasn't it added in someplace else? Number 1. So I think that's another red flag that goes up with regard to this. Now, there is a new development which you may or may not have heard of. By the way, are there any members of the press here today? No members of the press? Well, that's too bad. Because last Wednesday, a challenge to the entire constitutional amendment was filed in Champaign County Court by a John Bambenek. And it's Bambenek versus the State Board of Elections. Technically the Illinois State Board of Elections, but its short form is Bambenek versus Illinois versus State Board of Elections. And it's objecting to these constitutional irregularities. People don't know what they're voting on. There's only a summary, and the case is asking the court to rule this a non-binding advisory vote. Okay? Now, on September 17th, as was already mentioned, the League of Women Voters, a nonpartisan organization, advocating for good government, issued their public statement saying that they were in opposition to the proposed constitutional amendment. And I would add to what Merrill indicated here, some of the organizations, there's some other organizations that are opposed to this. The Illinois Education Association, Illinois Federation of Teachers, Chicago FOP, Retired Teachers of Chicago, State Universities Annuitants Association, not quite sure of that group, the FOP, and added opposition from labor organizations including AFL-CIO, AFSCME, Teamsters, Laborers Midwest, and McLean County. Those in favor are governmental interests, primarily Cook County and the city of Chicago. Now, let me point out one thing. My political scientist associates said that 2 months ago this was going to pass 80-20. A month ago they said it was going to pass 70-30. Now they're not so sure it's going to pass. And on September 25, a memorandum was sent out to legislators from Springfield leadership. And at the bottom of this memorandum, it says, under the subtitle, Ethics Acts Restrictions. A recent 9/25/12 legislative memo cites to the State Officials and Employees Ethics Act and states that a legislative, quote, member may discuss his or her support for the constitutional amendment during the spring legislative session, comma, but should refrain from advocating for or against passage by the electorate, end quote. In other words, today, if they have second thoughts. In other words, legislators having second thoughts may not speak about the proposed constitutional amendment, or they may be charged with an Ethics Act violation, or at least that's the one interpretation. And I think legal experts, including the ACLU, would have a significant problem with this. There are other problems with this particular constitutional amendment. I think those will probably come up in the question and answer session. I don't want to steal any more thunder than I already have from Dick Lockhart, and so I think I will close my comments at this point, except I'm going to mention where the $10 to $47 billion comes from. The $10 to $47 billion, first of all, the $10 billion. Casino licenses on the fair market value, you saw from my bio and others, my colleagues and myself have produced the United States International Gambling Report for several years, thousands of pages. Just brought 2 volumes. They're sitting right here on the stool, and it says right in there, the fair market value for a casino license is $500 million. The 10 casino licenses in Illinois were given away to political insiders for $25,000 apiece, including 2 to a person who was just convicted in the Rod Blagojevich scandals. Now that's $5 billion when they were initially given away. In today's money, that's $10 billion. And there are proposals in Springfield to give away more casino licenses for about $100,000 to $150,000 each. You start adding in all this bucket of cash, it's $10 billion to $47 billion. Now, and I've testified on this in Springfield, as have my colleagues. As a matter of fact, Speaker Madigan invited myself and others to speak to this issue, and you can even find my comments to the entire House of Representatives up on YouTube. One of my students put it up there. So the point is, Springfield knows that this cash is on the table, and they're not collecting it. So as my political scientist friends say, the best defense is a good offense. If you're looking for money, how about collecting some of the money that's owed the people of Illinois by a certain special interest group? And so I don't want to harp on that too much, but I just wanted to mention it as a possibility. And thank you for your time, Merrill, and I'll turn over to my colleague, Dick.
Thank you, John. Where's the portable mic? Have you got the portable mic? Our next speaker Richard Lockhart, has provided legislative consulting services to numerous not-for-profit clients, including financial services organizations, social service agencies, and professional groups for more than 50 years. Recognized as the Dean of Lobbyists in Springfield, Lockhart is highly valued as a resource among the members of the Illinois General Assembly. Since forming Social Engineering Associates in 1958, he helped to guide the successful referenda calling for Illinois' third constitutional convention in 1968 and 1970, serving as a special consultant to the President of the Constitutional Convention in 1970. Lockhart was elected Speaker of the Illinois Third House, that is to say, the lobbyists, in 1980, and was credentialed to cover every Democratic and Republican National Convention between 1964 and 1984. The Chicago Sun-Times has recognized him as one of the 10 best lobbyists in Illinois. Dick was a POW during World War II, having served in the U.S. Army in Europe. He was awarded the Bronze Star and the Combat Infantryman Badge. He was honored on the occasion of his 50th anniversary in his profession on the floor of the General Assembly in 2008 by way of a House resolution. For more details on his professional accomplishments, I invite you to view the video produced by his son on YouTube. Search term, Richard Lockhart Social Engineering. Mr. Lockhart.
Well, thank you very much for coming, and thank you very much, Merrill, for your leadership at the state level of the State Universities and Emeritus Association. The one thing you left out in the introduction is, and you should note this, I'm the oldest unindicted lobbyist in the state of Illinois. Thanks for your encouragement. The way I've started this out today, and I assume there will be a question period, whether there'll be an answer period or not, there will be a question period. I thought about how to do this, and I figured everybody here is interested in the COLA, so what I tried to construct here is the case of the missing COLA. So hang on there, there's clues that go along the way. And I'm one of those sinister persons who believe that when it comes to Springfield, expect the worst and plan accordingly. That has kept me busy for 53 years. In the narrative that I'm going to describe here, the first clue came when Speaker Madigan had a program during a non-legislative period in Chicago. His office called me up and said they're going to have a program on pensions, public pensions, and maybe I wanted to come down and bring my clients, and so I did that. The very first speaker was one who went on and on about the COLA and what it was costing the state of Illinois. He had a lot of facts. He really laid it on hot and heavy. It was number one on the Madigan effort to open up the public pension issue, okay? Clue number one. Clue number two came when the speaker introduced a constitutional amendment, number 5. Didn't do very much, provide for the 3/5 vote for all jurisdictions of the state if they wanted to have a pension increase. But it still was clue 2, in that it was a constitutional amendment. That was then withdrawn, 2 was withdrawn, and then emerged after a while Constitutional Amendment 49. That is the one the professor just described to you, this humongous, the beneficiaries of whom will be the legal professions in the state of Illinois. it's a wonderful asset for them to litigate forever in every county, every jurisdiction of the state forever. Local, state, and federal courts are all going to be put together, and it's go on and on if this amendment is adopted on the 6th of November. By the way, folks, today is the first day of early voting. Vote early, vote no. I know we're in Chicago, we can say something else, but, and I live in Chicago, so, but anyway, I want to get on, so that was clue 3, was the amendment that the professor described. That was number 49. This is the big humongous thing. And lo and behold, there's 42 words at the very end. That was that was the next clue. Now we come, the constitutional amendment 49 comes to a vote in the House Committee on Pensions and Personnel. The Speaker is there. By the way, the Speaker and I have been together one way or another since 1970. He was a delegate to the Constitutional Convention of 1970, and I was consultant to the President of the Constitution. That's where our paths first crossed. And we've been basically friends, although not necessarily always in agreement, but we understand each other and respect each other, and I do respect Speaker Madigan. He is a serious legislator. He deals with serious subjects. Don't always have to agree with him, but I do commend him for his concern for problems and ways to solve the problem as he sees it. But at this hearing of this constitutional amendment described by Professor Kindt, he spoke, he did not say anything about paragraph D. I spoke against the amendment, and I decided since he didn't bring it up, I would. And so I read the full text of the paragraph D. And I asked, I couldn't very well ask him, but the members of the committee sitting up there, like you're sitting here, there are 11 members of the pension committee. I really basically said, I do not really understand fully, but I'm concerned about the way that this particular amendment may be interpreted. I would like to know the purpose of this. Well, the Speaker didn't feel like he had to answer that question, because I wasn't asking him. That was a question for the members of the committee to ask him. Did any of them ask that? No. The Speaker is a powerful individual. Nobody raised a word about it until the voting came. They all voted aye. Every one of them. There were no questions asked. Nobody responded basically to my complaint about the amendment. That was the final clue to me. That was the fact that there was no effort to explain this away. And in my opinion, it will be used by the General Assembly to pass a legislation that will restrict or eliminate the COLA. Now, when could that be done, folks? It could be done soon. Soon. Let me tell you the legislative schedule. They're campaigning now, obviously. They come back for 6 days, the so-called veto session. 3 days in November, 3 days in December. That's the end of the 87th General Assembly. And the new people that were just elected, we're going to elect on the 6th of November, take office on the 9th of January, 2013. They're there for the next 2 years. Some of the senators are there for 4 years. But between the, say, the 1st of January and the 9th of January, the members who have been elected 2 years ago, even though they have not, some of them have been defeated in the primary election or in the November election, or maybe they're retiring, there's a substantial number of them. They still have voting privileges until the 9th of January at 12 noon. Okay? This is a scenario that you can expect if this constitutional amendment is adopted on the 6th of November. The legislature will be called back, and there will be a piece of legislation that will be on the calendar to vote on, and it will have something to do with the COLA. I don't know what it will say. Maybe it'll get rid of the compounding. Maybe I don't want to get into that, but something will be done. There's too much groundwork have been laid. Too many other things have taken place to indicate to me, all these 5 clues indicate to me this is a target. You're the human target, but this is what's going to happen. Paragraph D, I'm going to read it to you because there's something else I want to bring to your attention. It reads this way. Nothing in this section shall prevent the passage or adoption of any law, ordinance, resolution, rule, policy, or practice that further restricts the ability to provide a benefit increase, emolument increase, beneficial increase, as these terms are used under this section. This section is an amendment to Section 5. Section 5 is the impairment provision that has been referred to. So this is a way of going around, basically contravening the impairment. It says, the Section 5 says public pensions cannot be diminished or impaired. Okay. This says this section. We're still talking about Section 5. They didn't make this Section 6, this big long amendment that the professor talked about. They didn't identify that as Section 6. That's Section 5.1. It is a part of the diminished and impaired provision of the Constitution. Now, the question I have to ask, which is very seldom asked, notice the words policy or practice. Does this university have a policy manual? Probably. Probably. Is there something in the policy manual that under this constitutional provision could be negated in some kind of way? How about practice? It is the practice of the Department of Political Science to give the department head, after 10 years of honorable service, 2 weeks more vacation. Does that come within the definition of practice? Questions, all of these questions are raised. There's a question raised, in my mind, the governing issue. The governing body is used throughout this Constitution. But they do not define governing body. Who or what is a governing body for a state university? Is the trustees? Is it the trustees? Or is it, heaven forbid, the General Assembly? General Assembly funds universities. The House has a committee on higher education and higher education appropriations. The Senate committee has the Senate has a Senate committee on higher education. So there's structure there, conceivably, if they wanted to do that. Is the Board of Higher Education a part of the governing body? It is not indicated. It's just another road to go down by lawyers to determine one of these fundamental questions. So particularly for state universities, it seems to me, either by deliberate machinations, you are in the crosshairs, conceivably, of a lot of issues. The issues certainly of the COLA, the issue of all these things called the emolument benefit, all those things are going to be litigated. the issue of the policy of a university, is that going to be under scrutiny? Is the practice of the university somewhere along the line going to come into the purview of the General Assembly? I want to read another strange section, a strange paragraph, excuse me. An increase in salary or wage level by itself does not constitute an emolument increase unless the increase exceeds limitations provided by law. Suppose there are no limitations provided by law. I can't think of any offhand. Another world of litigation has been opened up, okay? I guess maybe I should stop pretty soon and be prepared to answer or dodge questions that may come by. And the important thing I wanted to leave with you, this Constitution proposal is of grave concern. Once this gets into the Constitution, this amendment, it's there for a lifetime. It's not a piece of legislation to be changed the next year. Not easily. Changing the Constitution is a process. Now, what does it cost, by the way, to have a constitutional campaign, not campaign, but what does it cost the state? I can take you back 2 years ago. There was what was called the impeachment provision of the Constitution, the recall provision, the recall. After Blago had departed the premises, they decided what the state Constitution needed was a recall language so they could recall the governor if he was a bad actor. That was on the ballot. It was non-controversial. Everybody voted for it. It's now in the part of the Constitution. The State Board of Elections was asked, what does it cost, what did it cost, or what will it cost the state and local governments to put the Blago constitutional recall amendment on the ballot? $70 million. This one will cost over $100 million. If you want to correct this constitution, if it gets adopted, that's another hunk of money, shall we say. We ran out of money a long time ago. All I'm trying to convey here, this is not a simple issue. It's not simple because I can prove to you the city of Chicago wants you to vote yes. How do I know that? They've put two advisory questions on the ballot, only in the city of Chicago. Let's try to get you to vote yes on those so you can be put in an affirmative frame of mind to vote yes on the constitutional amendment. I don't even know about these two amendments. You know about these two? One deals with the utility situation. I'm not going to read that one. But let me read to the next one because it deals with pensions. Should the state of Illinois, remind me, I'll just write up a bit. This is only advisory. If everybody in the city of Chicago voted for it, it still wouldn't happen, okay? But this is what it says. It's on the ballot here in Chicago. Should the state of Illinois provide funding for the normal cost of pensions for Chicago teachers in the same manner as the state pays for the normal cost of teacher pensions in every other school district in the state, which will free up local funding that could be used for others in the classroom. Very, what I want to say, objective question to put on the ballot, but you see the purpose here. That's why I say, I know the city of Chicago wants constitutional amendment to be adopted. Well, one other reason, the governing body for the Chicago School District probably is the 50 aldermen. 3/5 of the 50 aldermen for Chicago Public Schools, that's 30 people voting yes to get a benefit for Chicago's teachers. Do you think that will happen anytime in the near future? That's what goes along with the 3/5 requirement. And that is one of the reasons why the League of Women Voters are opposed to this amendment, because of the 3/5 rule. That really moves us away from majority vote decision-making, which is fundamental in every state and the United States. Going to move it to a 3/5, which really means the minority in every one of these 860 school districts, every city, every county, every township, there's 7,000, between 7,000 and 8,000 special district, library district, fire protection district. They all have a governing board, they have a governing body. They would all have to pass anything by 3/5 vote, which really would mean, in my opinion, a lot of these members of these boards just don't need to show up, and it becomes problematical. We've departed from a fundamental concept of local government in the state of Illinois by backing away from the majority vote making the decision. So those are my summations, shall we say. This is a serious, serious issue. Friends, neighbors, family, no vote. A vote no on this constitutional amendment is the only thing that's going to save this state from an enormous amount of problems and costs. Thank you.
Thank you, Mr. Lockhart. Michael, are we going to take some questions now? I'd just like to mention that for those of you who are interested, I have a number of yard signs in my car that say vote no. I did bring them with me on campus because of obvious conflict of interest with university rules and regulations. So after the event, if you'd like to walk with me back to Lot B2 next to the Union Building, I'd be happy to give you a sign. We'll take some questions now. Oh, I have to tell you an interesting story that happened just a couple of days ago. I had occasion to call the fire department in my village of Glenview. Nothing serious. But fire came out, and then as they were about to leave, they saw my yard sign on my front lawn. It says vote no on Illinois Constitution Amendment. And I pointed to the yard sign to one of the firefighters, and I said, you voting no on the issue? He looked at me with a very strong and fixed gaze, said, absolutely. And he paused for a few seconds, looked again and said, absolutely. So that was comforting. Okay, let's take our first question. Would you please identify yourself?
If you can just raise your hands if you have questions, then either Alam or I will come and stand next to you.
My name is Betty Medina. I used to work in the Benefit Center. I read this, and of course, you know, it's a mishmash like your copy. And one of the things I'm sort of wondering is,
My wife picked this up, by the way.
and in other occasions we would say it was lovely, but it is a mishmash much like this thing. It seems to me that maybe somewhere in here it is true. It gives them the ability to take away the benefits we have in the Constitution for our retirement benefits. But is it possible in that second part that maybe that has something to do with these outrageous things we have read about in the newspaper, where they suddenly give people their big benefits so that they can, after working for 2 days, get into some other. Is it possible that's in Section 2?
Well, yes, but they don't need that. They could do that now, and they have done that now. They hadn't changed the law. They didn't get to change the Constitution to do that. But there were people who manipulated the pension system, certainly, to advantage. No question about it. And people like the leadership of the legislature made that possible. This has got nothing to do with that, basically.
So it's not possible that
Well,
there's anything in there that
it arouses, I think what those incidences have done is arouse the interest and the negative attitude about it. People, we need to do something about public pension. This must be it. It's nothing to do with one or the other.
See, it just seems to me that a lot of that publicity in the papers and so forth, and I realize that somebody, I figure out what a small percentage of stuff that is, that a lot of people are going to say, yes, we want to vote for that.
You're right.
You know,
That part you're right. I would say, my political science friends say, that's why there's this focus on that and on the 3/5 voting, saying this is going to remedy that. But this is taking a baseball bat to hit a fly. I mean, as Dick pointed out, from a legal standpoint, you can pass legislation which addresses this, or you can tweak the regulations that address abusive situations. You don't pass a constitutional amendment, but they think that my political scientist friends say, they think that this is a PR move. The PR is on the side to move this forward. And I put up a copy of it here on the overhead, and you can see that there's this huge warning right at the front of it in large block letters. It says, hey, failure to vote this. In law, this is what we call leading question. Leading question suggests the answer. And the classic is, when did you stop beating your spouse? I made that gender neutral. You've heard it before. But that's a leading question. And so one of the allegations in the lawsuit here, the Bambenic versus Illinois State Board, if you can see it up there, is that in fact, this is a leading caveat or leading warning. It's warning the voters, well, you better vote on this. And it actually suggests the answer, and as Dick pointed out, on the Chicago ballot, there's an advisory that also suggests the answer. So my marketing associates indicate print size is important, phraseology is important, and this is very clever the way it's been done. It's just very clever. There is high-priced talent behind this. And the one that really disturbs me, and I really didn't move forward too much on this, is that last paragraph D. You can read that, it can be read to simply say the genie's out of the bottle and everything's on the table. And that, now, and I keep reading that, and I go to my legal colleagues and I say, am I misreading this? And a majority of them say, yes, this is a major threat, everything's on the table. Others, like Fred Geertz, who's a friend of mine, great colleague, but not a lawyer, he says it's less of a threat. But Fred said he's going to vote against it. Everybody says it's a threat. It's either a total threat or it's less of a threat, but it's a threat.
In other words.
Now, yeah. So as my associates say, if you trust Springfield, vote for it. If you don't trust Springfield, you should really vote against it.
I should add Mr. Belpenick, who filed the suit as a candidate for the state senate.
Did you want to mention anything more about that? Or?
Well, it's a minor point. Candidate Bambenic that you heard Professor refer to filing this suit, don't get too excited about that suit. I think it's a campaign tactic. He's a candidate for the state senate.
Well, I would disagree with you on that.
He's not a campaign.
Well, no, I know he's a candidate. I would disagree that the fact that about this suit. I think there's a 50-50 shot on this suit, and there's a likelihood it would even go to the Illinois Supreme Court. Now, guess who's going to have to defend this suit? It's going to be Lisa Madigan, who's going to drive in from Springfield, right, to defend this suit in Champaign. And so the fact that a candidate, and I just make this as a generic statement without any endorsement, spends time, resources, limited money at this point in the season to invest in this, I'm not sure that it's not counterproductive, but it's a person I think who, or my colleagues might think is invested in good government, and who, by the way, got the endorsement of the Chicago Tribune. And that's not my endorsement, by the way.
I'm Bill Troyer. I'm a professor of medicine emeritus. I'm in my home territory. I've forgotten what I wanted to say. I'll get back to it.
I'm Brenda Russell, another professor of medicine emeritus, so this is where the med students have their classes. So my question is, looking at that page you've got with the yes/no ballot, if you pull that top one off, and obviously I do know about this, but if I read that, I would think that I'm voting to block increases in pension. Requires a 3/5 majority in order to increase the benefit. But what it really is a way to cut benefits for those of us who've already retired or those working, earning towards future benefits. Isn't that a lie?
Well,
I mean, as a lawyer, is it a clever lie?
that's actually alleged directly and indirectly in the lawsuit that has been filed in Champaign County. And also, the lawsuit points out that by state law, the lettering has to be in a certain block format, and it is not in that format on the Champaign County ballots, and I presume on some other ballots throughout the state. Actually, there was a law passed that said that you had to print these ballots in a certain way if there was to be a constitutional change, and that's one of the constitutional challenges. I personally don't want to specifically address your question. I think the point is, in 700 words, everything is open to interpretation, as I think Dick correctly pointed out. And the people who are pushing for this want people to be confused.
That's, the sentence I read is, if you believe the sentence is a few words.
In the explanation of the amendment, let me see if we can blow that up a little bit.
It's at the bottom now. Should be, I mean, people are going to read, that's short.
Right.
It's not 700.
Well, the point is, the amendment itself is 700 words long. It's not on the ballot. People can't even read the paragraph D. They can't read paragraph A, B, C, or D. They can't read any of the 700 words. There's only a summary that says, basically, trust us. And so my political scientist,
Increase the benefit.
well, who made the phraseology of the summary, the explanation of amendment? I mean, who did the phraseology on this? And I think you raised a very good question as to words are powerful. This is phrased in a certain way. Why is it phrased that way? But I think we need to get back to the real gravamen and say, why is this on the ballot to begin with? And not get lost in debating the details unless it passes. If it passes, then all of this is going to be on the table. If it doesn't pass, it's a moot issue.
Just want to fill in a historical thing. This is prepared by the legislature. They prepared the arguments for and against. They did not say anything about paragraph D. That was in House Joint Resolution 93. That was passed in the closing hours of the legislature back in the end of May. So that's how this language got there. The legislature put that language, and it was encompassed in Resolution 93.
I stand partially corrected. Thank you, Dick.
My memory's been restored to me. The people who took advantage of the pension fund to double dip, particularly members of unions who hired on for one day as teachers so they could get into the teacher retirement system and so forth.
Keep it up by your mouth.
Those certainly are egregious acts, but a friend of mine, but economically, they don't make a dribble. A friend of mine, a colleague, calculated, all those that he learned about, and the total amount of money that they got, you know, on an annual basis is something less than 1% of the amount of money that's paid out by the pension funds. It's a trivial amount of money. It's a heap of, though, it's worth, you know, a lot in bad publicity for honest people like everybody in this room is.
I'm Sheila Castillo, and I'm the Associate Director of the Midwest Latino Health Research Training and Policy Center. My question is, I guess it's not really a question, I'm just asking for clarification here. So what we're talking about is every pension, a government pension in the state. So it's not just us, and it's not just the teachers, you know, it's a teacher in the IFT. It is every police, firemen, all of these pensions. Yeah. Now, in the paper that we received, it looks like every change in those pensions will require a 3/5 majority in the General Assembly.
No, by the local board, the local governing board.
Okay, so whoever governs, so it would be the village, you know, the village trustees.
School board,
Et cetera, who does that. All right.
Townships.
Now, how is this, they're wiping out the COLA, that's the, you know, so that's future costs. How is this affecting the money that the state currently holds for pension? How are they using this? I don't share your admiration of Madigan. You know, I think he's trying to find his way, and, you know, I see him as a self-serving person. How is this helping him and helping the state to get out of the hole that they've dug over the past year? I don't need a lot of explanation. I would just like to know, how is this playing into that?
You want to keep that?
Yeah. Hey, you've got 50 years in Springfield. I bow to you, seniority.
Well, I guess I'm not quite sure. I'm not sure that there's a relationship in the first place between the pension benefit or not benefit and the pension funding, shall we say. This does nothing whatsoever for pension funding. Got it? We're still 85 million or whatever it is in the hole on pension funding. So it's got nothing to do with that.
This is all future.
Yes,
So trying
right.
to control the cost.
Want everybody to understand that. It does not solve the funding problem.
Well, I think related to what I was saying earlier, this is a bit of a misdirection of the real issues. In other words, it's a transfer of responsibility. It says Springfield is saying, oh, we're not responsible. We're going to put it on the ballot, and now it's the responsibility of the people of Illinois to make the decision where we go on this. So my colleagues have raised this point, and I think that's a very salient type of point. And I appreciate the comments by my other William & Mary associate here, a professor from Williams College. And but this is a huge thing, and as Dick correctly pointed out, once this constitutional amendment passes, if this passes, this is going to be there forever, and it's going to raise all kinds of problems administratively across the state. And the other final point I want to mention is interpretation of this final paragraph is that we're not just talking future benefits here. We may be, in fact, talking about what is a beneficial determination. It says further restricts beneficial determinations. Well, that could be past beneficial determinations. When my colleagues say the genie's out of the bottle, and I start reading this, and I'm like, I think you've got a point. The genie would be out of the bottle on this. And for people just in the general public who have think they have no dog in the hunt. In fact, this affects everybody in the state of Illinois. It's not going to solve the budget problems. What it really does as a practical matter is it takes power out of local governing authorities and reconcentrates it in Springfield. And it concentrates it in Springfield with interpretations where they can swing the interpretation any way they want to in 730 plus words. I get a little excited about this, but maybe that's from my classroom teaching. The students want to be entertained with excitement, so.
How does it reconstitute? That's where I was asking about what I read here.
Well, when the decisions, yeah, when the decisions for all the people of Illinois are now going to be concentrated in Springfield, when they're taking away power from local governing authorities throughout the state, particularly the smaller governing authorities, that gives more power to the people who are in Springfield and the leadership that is in Springfield. And so,
Give me an example. I'm sorry, I'm still not.
well, yeah, well, first of all, the interpretation of the words are wide, and that, right, they can swing that any way they want if this constitutional amendment passes. And if anybody challenges, they're simply going to say, oh, hey, it's in the Constitution. It's in the Constitution. Ball game's over. But the other thing is, and the League of Women Voters brought up this point in their opposition to this, is that in fact, it changes the majority vote that was good enough for Williams College, for Thomas Jefferson, for John Adams, for Madison Monroe, for all of our forefathers. We've had majority vote forever. What's this 3/5? What's this all about? This is changing the ball game. This is changing the fundamental rules in Illinois. And no other state's doing this. It's just Illinois. Why Illinois? Well, a transfer of responsibility. We can move it into the general public. If they pass this, the power comes back to Springfield.
I have a question.
Yes, sir.
I read a lot of the questions that were submitted in advance of the presentation, and two of the most common were, I'm a current employee. What does this really mean to me and my retirement, my pension? And then likewise for the people who have already retired, how will it directly impact them?
I would just say an increase in instability and in proposals that come forward. My associates say the genie's out of the bottle. Those who have been very cynical from my political scientist friends say, if this passes, something that's got leading questions, something that's not even on the ballot, people don't even get to read it before they have to vote on it. If this passes, what does that signal to Springfield? We can get away with anything. That's the message to Springfield. We have done this to the people, or we can get away with anything. We can pass anything. If we can pass something this sloppy, and even though it's got a lot of high-priced talent behind it, it's just sloppy. 730 words.
Hi, I'm Margaret Moser, Office of the Vice President of Health Affairs. My question is, what is the most compelling thing that I can say to my friends who are not in a public pension system, who are working hard at jobs remotely in Illinois, or they don't have even a retirement plan? What is it that I can say that would make them want to protect my pension and the pension of other people in the family?
I'll say one thing and then let Dick, and I'm sorry to dominate Dick. My colleagues say, if you trust Springfield, vote for it. If you don't trust Springfield, vote against it. And that's really sort of what it boils down to in a point.
That's like you're appealing to cynicism or distrust of the state more than...
Well, that's what the amendment is appealing to. The amendment is saying, trust us, we're not even going to put it on the ballot.
I'm just going to add, there's a slogan, of course, that we know we're all in Springfield. Well, the first one is, there's no law against bad laws. Sounds simple, right? But it's true. This amendment will affect the current employees, it will affect retired employees, because the retired employees have been counting on Section 5, Article 13 of the Constitution. It says no public pension shall be diminished or impaired. That is being countermanded, in effect, set aside by 5.1, the section D of 5.1. So that's protection is gone, in my opinion, is gone. Okay, if this amendment is adopted. There's a slogan in Springfield, no man or woman's life, liberty, property, or pension safe so long as the General Assembly is in session. Expect the worst and plan accordingly. It's a safe strategy. Complacency in the state of Illinois is dangerous, shall we say. Do not be complacent about what happens in Springfield.
My name is Steve Sossler. I have a question relating to the lawsuit, and could you speculate on, it's 2 weeks till Election Day, can you speculate on a timeline for the outcome of that lawsuit? Either way.
Well, those who have brought the lawsuit are going to try to move it quickly to get some type of a resolution or some type of a ruling within the next 2 weeks, obviously. And we'll just have to see what happens. But they are anxious, and they are moving as quickly as they can. I've had people who are right on that particular case advise me that that is what they're doing. I'm not involved with the case per se, but obviously I'm just as interested as you are, and so I've had some firsthand contact with the attorney involved who sent me copies of the complaint and the memorandum filed in it, and I haven't talked to him recently, but he told me at the time that they're moving as fast as they possibly can.
If it can't be solved before
Okay. I am an attorney, but I'm not practicing. I'm teaching because I can't do, therefore I teach. I knew you'd all appreciate that. But there's really, it's tough to predict what might happen with regard to this. The court could simply say this is going to be an advisory vote only and has no constitutional effect because of all the procedural violations in the way that it was listed on the ballot and the violation of existing Illinois procedural law. Or the judge could simply dismiss the suit and let it go forward. I think it would be reasonable to suspect that there would be about a 50-50 chance this would go to the next level of the courts, probably even directly to the Illinois Supreme Court because of the time frame to see. But there's really no way to predict what the judge in this case would do. But Mr. Bambenek has brought a case, John Bambenek has brought a case similar to this before, about 4 years ago, and they were 90% successful in that particular case. Whether this will be successful to that extent, there's just no way to know.
I just want to add, because we do differ here somewhat, the critical day is 6th of November. This amendment has to be, that will solve the case if they defeat the amendment. The Supreme Court, there's 7 members of the Supreme Court. They all got there by a political process. They got elected to it, they got nominated, and got elected. Everybody understand that's part of Illinois politics. Some good people, nevertheless, come to the surface, but they're the product of the Illinois political system.
Yeah. By the way, there's a fee of $10,000 for everybody who's attending today. Just write a check. It'll go into the court costs of future court cases if this passes. The point being that it's going to be a huge expense to go to court on a multitude of issues. And as Dick says, the the Achilles heel of this constitutional amendment is people informing and educating the public on both sides of the issue, but particularly what hasn't been reported much in the press.
I could just say, in case of doubt, vote no.
By the way,
Otherwise, it gets in the Constitution. You're not going to get it out of the Constitution.
But by the way, several, as Dick pointed out, to put this on the ballot, everybody in the House voted in favor of it or voted absent or present, and only 2 senators voted not to put it on the ballot. So basically, the entire legislature voted to put this on the ballot. However, since the backlash has started, quite a few legislators, despite the memo saying, we don't want you talking about this, have had second thoughts and have publicly stated that they personally are going to vote no, which is, considering the memo that says we don't want you talking about this, or it might be an Ethics Act violation, that's, I think, a significant factor.
One more question.
Is it, gentlemen?
I'll speak loudly. Willie Bryan, Information Services. Assuming worst case scenario, let's say it does pass, Mr. Lockhart, you said that you sincerely believe that the COLA is going to be one of the first things that is
I do.
attacked, and I believe you. I sincerely believe that too. So let's say, for some strange reason, I hope it does not, but let's say the COLA is gone. What about benefits that have already been earned? Benefits that have already been accrued or earned, those would pretty much can be eliminated or reduced also. So in other words, benefits that retirees, people that are already retired, have earned, can they be reduced? And those benefits that current employees have already earned, can they also be reduced or eliminated?
I'll leave that to my lawyer.
COLA is the primary thing they're going after, but to what extent do you think that benefits that are
COLA
already
going
earned?
forward, though. COLA going forward, right.
Okay.
I don't think they can retroactively, let the attorney here.
See, that's the argument. We're going to argue back and forth, and I'm sure people are going to argue just the opposite of what Dick Lockhart says, and the opposite of what I say. It's up in the air. There are so many nebulous terms in this that everything's up in the air. And theoretically, you could argue it's a blank check to the legislature. As my colleagues say, if they can pass this when it's not even on the ballot, that's going to embolden them to pass all kinds of bizarre legislation, retroactive perhaps even. So everything's up in the air. But if the door gets slammed shut on them now, and a lot of these, as you know, I said, Speaker Madigan's invited my colleagues and myself, and we respect him very much, and many of the legislative personnel. They are indeed serious legislators. But the signal is going to be antithetical to perhaps the very best interests of all the people of the state of Illinois. It's going to be a blank check type of signal.
I just want to go back to the 2 words I mentioned in paragraph D. In addition to the legislation, they can look at policy, practices, okay? Scary. That's kind of scary come to my, I don't think the legislature should get involved in those kinds of things, but it's in the Constitution.
Okay, we're going to call the event. One more question.
Hi, my name is Bill Weiss. I'm Administrative Services Chancellor. First, Mr. Lockhart, thank you for your service. Appreciate it. My question is really for Merrill Glassman. What is SUAA? Is SUAA going to have any kind of plans to advertise, via television, to defeat this bill? It's just a few weeks away. It's going to be limited impact from grassroots perspective.
Good question. Are you a member of SUAA?
Not yet.
Not yet. Well, if you were, you would have been receiving some of our mailings one of which went out first week in September, outlining talking points related to the amendment for your personal use in contacting friends, families, local press, and to do persuasion to defeat the amendment. We also had another mailing about a week ago, and we're having a third mailing to our members before the election, towards the end of this month. In addition to the mailing, and you can appreciate, since we have over 15,000 members statewide and even beyond the borders, it's expensive, it's costly, but in addition, we are embarking on a Letters to the Editor campaign. Some of you may have seen the letter that I and my fellow board colleague Brenda Russell here wrote. It appeared in UIC News last week, outlining the reasons why you shouldn't vote for the amendment. There was also a letter to the editor in the Chicago Tribune recently by Nancy Cohn from this campus. I don't know Nancy personally, but I publicly thank her for writing a very nice letter against the amendment. But more to the point of your question is, SUAA will be placing ads in the various newspapers around the state of Illinois. I don't recall how many, but it's a fairly expensive endeavor, and we're going to try to reach as many people as possible through their local press. So we have a number of different avenues that we're approaching. We've allied with the unions and other organizations. We're working with them. So we hope that you'll see things in the direction that you've heard today. And again, if you want to sign, come with me to my car. Anything else? Thank you very much.
Yes, in a heartbeat.
Only because my mother was trying to answer better,
Well, Williams College, Professor. Nice to meet you. Nice to meet you. I enjoyed your remarks. I learned something too. See how it goes. Yeah.
Meryl, I'm going to walk you to your car. I'm just going to run to the restroom, and I'll be right back.
Let's do this. Do next week.